Another walk and talk with a church attorney. This one might surprise you. I'm going to talk about when not to hire an attorney. So, obviously, as a church attorney, someone who has completed 4 years of undergrad, 3 years of law school, 1 year of a clerkship with the chief judge of our state's highest court, and practicing for over 25 years, I have had the pleasure of providing legal services to churches and faith-based organizations, which is the passion of my heart. And I also want you to know that there are some times where you can do it yourself, but please stay until the end, because there's a critical time when you absolutely should not. So let me give you 3 examples of when your church doesn't need to pay the money to hire an attorney. The first example is when you're wanting to confirm some basic corporate information about your church, right? So things like your official legal name, the status of your good standing, right? Whether you're in good standing with the state which you are formed. That information is readily available through your state's Secretary of State website. So every state and the District of Columbia has a website and varying levels of information available, but generally with all of them, you can access information about your church's for data formation, your status in terms of being in good standing, meaning that you are able to operate, you are current on the things that allow you to operate in the state, etc. So you can get that information from the Secretary of State website. Don't need to hire an attorney for that. Second example is when you are looking to make certain internal shifts within the church. Let's say you are looking to add a new ministry, like a new outreach type ministry, or you're looking to maybe shift from 2 services to 3 services or something to that effect. You definitely can start that strategy consideration internally. There may be legal components, like certainly if you're doing anything where you maybe are creating a new childcare center or a school or something that might be a separate legal entity, for sure, seek competent legal counsel. But service schedules and times, things like that, all internal. Morning. A third example of where you don't need to hire legal counsel, and again, hang around, because the end, I'm going to tell you when you absolutely must. And honestly, that's really important to know. A third example is something like when your church wants to maybe make certain expenditures, right? You're making the decision about buying new equipment, and maybe these are things that you're also trying to manage within your church budget. These more fiscal kinds of arrangements probably can be managed internally with your board or with your bookkeeper or accountant. Now, when must you absolutely reach out for assistance from legal counsel? There are several examples, but let me just end with this one. You must reach out for at least a consultation with legal counsel if you get a letter from an attorney, a demand letter of some sort. If you get a subpoena from an attorney, really, that comes from the court. if you get any other kinds of service from that involves litigation and your church is in litigation, do not go it alone. And I know one of the concerns, and understandably, that churches immediately have is the cost of legal counsel, but I promise you will, in all likelihood, pay a lot more and experience a lot more hardship by not investing in legal counsel at the start. And I say this because just this past week, I saw a church that had gone to court by themselves, and unfortunately, judgment was entered against them. They didn't have legal counsel, and we're talking about over, when it's all said and done, over $500,000. And I promise you, that's not the money that legal counsel would have cost. It would have been a fraction of that, and the church wouldn't have ended up with this default judgment. So just imagine if you are a giver, right? If you're a donor, if you're someone who provides your tithes and offerings to this church, and they did not do I would say the bare minimum to secure representation, it doesn't look good before the judge when you come into court and you're not really, the way that the court looks at it is that you're not prepared. You don't have legal counsel. And I know that the church is a place of faith, and there's a legal component of church as a corporate entity. So this is not something that even small businesses would consider really doing, meaning going into court generally without counsel. So when you show up and you don't have legal counsel, and God bless that you have a lot of capabilities as church leaders, but court is something that even people who are lawyers, not everyone is a litigation attorney. So it's a very specific, they have very specific rules, very specific operations. And now this church that has a judgment against it, now they're like, oh, we should get some legal help, right? The problem with that is you already have a judge that's put down, in this case, his gavel and said, I find for the plaintiff and against the church, right? So now you want to appeal, and so you're looking for another judge to overturn that judge's decision, or even in some instances, if it goes back to that judge, to overcome or overturn their own decision. It's just, it becomes increasingly less likely. So know when to say when, right? There are circumstances where you can absolutely DIY it, but court, it's not one of them. Make sure you like this, share this with church leaders who should have this information. Be sure to subscribe to the church attorney page so that you can continue to get information like this. And you can get our free newsletter where we send out information like this and more so that your church can stay on top of the critical legal insights it needs to operate in today's climate. That's today's Walk and Talk. God bless. Bye.